Good afternoon. I'd like to welcome everybody to this Oxfuse webinar on FRAND treatment of early and late licenses, presented by Clemens Roche from Nokia and Richard Roy from Bird & Bird. Thank you all for joining us at such short notice. We're very happy to welcome you. The webinar is being recorded, so if you can't crack it, to stay on for the whole session, which I hope you will, it should be available online eventually. For those who don't know Oxfuse has launched this springtime, and it's a spin-out from a spin-out. And the idea about Oxfuse is to offer a neutral platform for sharing opinions, views, ideas, suggestions, proposals on all matters around intellectual property and competition law and economics. The first granting which Oxfuse is running is our Intellectual Property and Competition Conference, which is taking place in Munich in June 21 and 22. If you're interested, please send us an email, get in touch, check out the website oxfuse.com. So not like fuse like fusion, but fuse like opinion. Yeah, and with all of that being said, so a few words about our speakers. I don't think they really need an introduction because the people who signed up here, this is like a small group of people who tend to know each other all of the time anyway. But nonetheless, we could have a newcomer. So Richard is partner with Bird & Bird. Before that, he was the senior vice president of Nokia's IP, I think, the decision maker. Clemens is with Nokia, is head of European litigation. And he has a PhD in law from Germany and is running pretty much a lot the litigation business of Nokia quite successfully, as I gather, as reflected in his bonus payments. So the topic they wanted to talk about is about FRAND treatment of early and late licenses. I think it's a very interesting question because it is asking how can you better factor in time when pricing licensing agreements and pricing what people should be paying for the usage of standard essential patents. And I think this reflection of time periods is probably another great way to better encapsulate how to determine FRAND rates. That's my personal view. I'm muting myself. Clemens, Richard, you have the floor.
So good afternoon, everybody. Thank you very much. The question of timing on licenses and how you then regard them when you're trying to determine FRAND has received a little bit of consideration, but not very much. So, for example, in the Unwired Planet case, what Mr. Justice Burst recognised was that licenses that are closer in time to the one that you're trying to determine are probably a better comparable, but he didn't go any further than that. In some arbitrations that we have done, we've also recognised that there is a time factor in licenses, and the time factor there is often that the portfolio changes and evolves over time. So if you have a growing portfolio, then a license that's entered into early on, you may need to scale up to reflect the fact that at a later license, the portfolio is now significantly bigger. And therefore more rights or a greater share is being licensed over the time. And equally, if you have somebody with a dwindling portfolio, an early comparable might not be such a good one because it may be too high. It may be that now you're taking a license to the dwindling portfolio. But those are elements that can be quantified. There is a much bigger question which hasn't been addressed so far in any litigations. And it was prompted by a comment that Lord Justice Jacob made at a conference only a couple of weeks ago in Venice. This is the LESI conference. I'm sorry to mention a rival conference to the Oxford one, but I will do so. And what he said was this. He said, you would not be FRAND as a licensor if you granted the same terms to somebody who only took a license relatively late in the implementation cycle to someone who had taken one early on. In other words, you are discriminating against the guys who took an early license by giving the same terms to the person who only comes to the table late. And so that prompted this question: is it FRAND for a SEP owner to grant licenses to late licensees by which I mean people who have been implementing for a long time, but only take a license late in that implementation cycle? Is it FRAND to give them the same terms as the people who signed up to a license right at the beginning? And obviously we've heard Lord Justice Jacobs' opinion. He says very clearly no. So the problem is this, effectively. I've got here two timelines that demonstrate, for example, let's assume that our FRAND rate for a product is €1 per device or 1% per device or whatever. The products launch on around the same date, let's say when LTE is implemented as the standard and people rush out their 4G phones. One person takes a license after a fairly short period of negotiation at their €1 per device or 1%. And that's the person at the bottom here. So the blue section is him paying 1% or €1 per device from the date he takes the license. There's a little green bit, which is the past payment. Inevitably, when you agree and negotiate and agree a license agreement, there's some payment for the past. But it always seems to be discounted in my experience. Maybe by 50% I've discounted it here or whatever, but it does seem to get cut down a bit. So you can see that the bottom guy who takes the license early on is paying a large chunk of time, 1% or €1 per device, and a fairly small chunk of time, let's say €0.5 per device or 0.5%.
Richard,
yeah, go ahead.
Sorry, just to add a few sentences from the business reality here to this. We all know two sentences: time is money, and everybody knows it. And maybe even more precise here, hold out pays out. These are two sentences we hear quite often, and I think this here demonstrates it quite well. The problem we are facing is, first of all, many people have their targets for this year, for next year, so they, let's say, need license agreements rather this year than next year. The second point is that that whenever how later it gets, how more difficult, the more difficult it gets to realize the true value. And this has just been demonstrated to us by a number of court cases where the judge explained to us that he thinks FRAND behavior means that companies are getting closer to each other. And that is, of course, the opposite to what Robin Jacobs said, because if we think that delay should be kind of punished or not punished or disincentivized by increased royalty rates, then it's a contradiction to the idea that, let's say, the longer you wait, the more the figures go down. And I think that is exactly the clash which we try to address here, because if indeed it would be always the case that the longer the negotiate, the longer you wait, the more the licensor has to go down with its offer, then delay would really pay out. And I think that is then a big incentive for users, for implementers, to wait as long as possible, hoping to get the best deal. Or in other words, it would then be a disadvantage for those who act, let's say, lawfully, legally, who try to get licenses before they enter the market, or even, or at least very shortly after they enter the market, to make these good people kind of those who in the end pay most. That also seems from a legal perspective inappropriate. And that is the reason why we wanted to spend some more thoughts on this relationship between time and payment.
Exactly. And this, on this slide, the top guy is the guy who is delayed paying. And he's benefited not only because there is a shorter period of time at which he's paying the higher rate, and a longer period of time at which he's paying the sort of the lower rate, the rate that you pay for pass sales, but he's also benefited on this slide because of the limitation periods have started to come in and chop off past sales. Now, limitation periods in the UK are 6 years. In China, it's 3 years, of course, where most mobile phones are made. And the duration of negotiations is quite often of that order. So it's not unusual to start to see limitation periods coming in and cutting off the early sales. I think, Clemens, was it Daimler? They launched their first connected car in 2008, and they've taken a license in 2020. Was it? So
it was 2020. So indeed, it was more than a decade in between. And also, worth noting is that there are some companies, not naming anybody here, but who never even care about licenses. And there's, I think, the wrong understanding from Huawei ZTE that you can use the patent until you get approached. That is, of course, a wrong idea. you are acting illegally whenever you use third party's IP without being authorized. And Huawei ZTE does by no word say that you can wait until you get approached. This is only on the question whether there will be an injunction. But if the licensor, for whatever reason, does not get an injunction, this does not mean that any action is legal.
Yes, indeed. So what we've got, the result between these two guys is that one of them has got higher cost per product because he's carrying a higher overall royalty burden on all of his 4G products than the one who has taken longer to pay. The one who's therefore taken longer to pay has the benefit that his products basically have a lower bill of materials cost to them. The cost of production of them is effectively lower over the product cycle, so he can sell them for a cheaper price, and that means he can grab market share at the expense of his competitor, who is bearing this higher bill of materials cost.
Let me just pick up the first question in the Q&A from Ilko Bergsma. He said that he assumes that the difference between the upper and the lower bar can be compensated by lump sum payment for the past. In theory, yes. In practice, no. Because coming back to licensees who join the market, let's say, or who get licensed only 10 years after joining the market, let's say that's the lower one. Sorry, that's the upper one compared to the lower one who joined who took a license very soon after entering the market. You see how much the lower one has paid. On the upper one, in theory, it is right, he should pay the same for the past, maybe plus even some penalties or some late payment fees on top. But practice is that this is very, very difficult to get. He will tell you that, first of all, a lot of claims going more, depends on the jurisdiction, more than 3 or 4 or 5 years might be time barred. On top of those, the person will tell you that it is very difficult to claim past damages because it's, I think, the case law in all jurisdictions I'm aware of that you can never get it all in one go. You would have to do it patent by patent, country by country, and we all know that this is in practice impossible, and that is the reason why it is so difficult to collect the full fees for the past.
But you're right, Elko, and that this is what has, I think, prompted Sir Robin to say that maybe we shouldn't be giving the same terms, that same 1% or that same €1 per device to the later person. There is also another point, which is that typically the value of a technology or the average selling price of phones with particular standards in decreases over time. It works like a sawtooth. So you'll have a peak when 3G comes out, and then the value of 3G technology or the average selling price of 3G phones drops away. Then you get another spike when 4G comes along, and that drops away. And then when 5G comes along, we get a further spike, which drops away. So because you have this sawtooth pattern as well, if you can be the one who takes a license to 4G late on in the sawtooth, and you're paying an ad valorem rate, say 1% of the 4G average selling price, then again you've missed a large chunk of those really expensive royalties right at the beginning, and you're now paying your 1% on your tapering 4G price as it trends off before 5G comes in. So there's that other point in there as well, which also benefits the late licensee, and I think is why Sir Robin is suggesting that perhaps the same terms would be discriminating against the early licensee if the late one takes them. So that's the problem from the point of view as between competitors. It's giving one competitor, the one who takes the license late, a significant advantage over those who take the licenses early, and that advantage can translate into them grabbing market share at the expense of those competitors who have taken the earlier license. Also look at it from the point of view of research and development. If you have 2 people participating in the standards development organization, and one of them has a fast licensee take up, a lot of people who take up the licenses very quickly, then that's the guy on the left here. Very much more of his research and development costs is getting refunded by way of the royalties. So he's then much more able to contribute to the next generation of research and development. The one who's suffering from slow licensee take up on the right here, his much fewer of his R&D costs are being returned by way of royalties. So he's much less able to contribute to the next generation of the technology. He's got less income coming in, means he can spend less on his own engineers. So you can see also that there is a, from the point of view of the patent owner, there is again a very great reason to try and incentivize fast take-up of licenses and disincentivize the slow take-up of licenses. And from society as a whole, if we want the next generation of the technology to be developed quickly, again, we want to try and incentivize fast take-up of licenses over slow. So you can see there's that side to this as well. So this got us thinking about what are the solutions? How do you encourage or structure your licensing program to be FRAND, but at the same time to incentivize a fast take up of licenses, or to not discriminate between the person who's taken a license early and the person who's taken a license late? So one of them we've seen, the third example here, you've seen the compliant and non-compliant rates. That appears in various licensing programs. I know Sysvel has it in theirs, and I think I've seen it in some of the other pool license agreements. And a compliant licensee is someone who takes the license without being sued for it. A non-compliant licensee is someone who doesn't. The reality, though, seems to be that everyone ends up being a compliant licensee, because even though they're sued, eventually the settlement comes along, and they take a license and they become, as part of that, a compliant licensee and pay the compliant licensee rates. And I know that in some of the FRAND cases where those sorts of things are being debated, there seems to be an assumption that the only real rates that are relevant are the compliant rates. So again, very quickly we end up at that. So I'm not sure that's working.
Yeah, just one more point to add here. We often hear that we are, of course, committed to FRAND licensing, but FRAND by no means means best treatment. FRAND means not discriminating without a justification. And you can distinguish. You can, for example, say that somebody took a license without litigation, therefore less transaction costs on licensor side, and that can be a justification to grant better rates. And there are all other kind of differentiators available. And so therefore, I think we must get away a little bit from always asking, what are all my competitors paying? I want exactly the same. That will probably not work in the future.
Yeah, the transaction cost argument also, it exists, but it always seems to be a little shallow, because actually the transaction costs are not that great in comparison with the sums quite often being licensed. I mean, I know we save on airfares, we save on salaries if you need fewer licensing personnel, all of that sort of thing, but those aren't huge. The much bigger point, I think, is the opportunity cost. So most large organizations, even the large organizations, can only really deal with one dispute at a time. So if you're having a 1 or 2 or 3 year dispute with a licensee who is you're having to litigate with, that takes all of the company's resources, and during that nobody else is signing up licenses because they want to sit and wait and see what happens. So it's the real cost of the licenses, of the slow licensing process, is not so much the airfares, it's the delay in everybody else taking a license, and the fact that you can only get licenses signed up one at a time over a quite long and slow period, and that can't adequately be reflected or compensated or calculated, I don't think, by economists. It's a very big cost, and it's the thing that puts you back in the on this slide. It puts you on the right hand side, not the left hand side. So there's that. The other option, I suppose, is to have a genuine license or renewal without litigation discount, which absolutely falls away when litigation happens and can't come back again. So sort of like the compliant and non-compliant rates was probably supposed to be. But again, it's very difficult, because when you, as part of settling the litigation, the licensee is of course going to say, well, I want the discount, and the pressure to give it and move on is going to be enormous. The third one that I've seen discussed is the idea of a discount for renewing before an old license expires. So if you have a license agreement that expires on, I don't know, they always seem to expire on 31st of December, which ruins everybody's Christmas. But if there was genuinely a discount that could only apply if a new license was taken before the old license expired, that again might encourage a more rapid take-up of licenses. Is that something you might consider, Clemens?
I think it's definitely worth something to consider. And as said, I think here creativity can also be very useful. I think it should be always the aim to find a solution which, let's say, gives early licensees a benefit, at the same time also enough certainty for let's say, for example, if the market develops different than expected, or if there are other unforeseeable. So I think that should be the aim, to find really win-wins here.
Good. Okay. The other question is about limitation periods. This again was raised with Sir Robin. One possibility is that if an one view is that if an implementer is truly wanting to be FRAND, he will waive reliance on limitation periods. He won't say that by dragging these negotiations out for 3 years, all of my past sales from there should be washed away. And one possibility which I haven't seen done, but I have thought about, is whether at the start of negotiations, when you sign up the non-disclosure agreement, there should also be in there a tolling agreement, a tolling of limitation periods. Now, we see that in many other legal disputes. For example, if two parties agree to start a discussion about an ongoing contractual breach, and they want to reach some sort of negotiated settlement, one of the first things they will do is sign up to a tolling agreement, which tolls limitation periods. They say that as of today, no further limitation will wash away past liability. But it's not something that I've ever seen used in a patent context. And I'm wondering actually if this is a practice that we should start to encourage, and we should start to say that a willing licensee signs a tolling agreement.
I think the problem on top of this is that, let's say, even filing a legal action, and this brings us back to the point I mentioned earlier, that you have to claim damages patent by patent, country by country. So this means even that a patent infringement action will only stop the time limitation for that patent and for that jurisdiction. So this means there's no way to stop the time limitation by just filing a, let me call it, random action. On the other hand, of course, if you do it, let's say, the English or German approach, that you say you need to take a FRAND license in order to avoid a national injunction, in that agreement, the court is free to consider whether the offer is FRAND, whether the licensee has to accept that offer in order to be a willing licensee. And in that regard, the court is not bound to any limitations. So let's just say an example. I have a lawsuit in the UK. My patents are validated in 10 countries, including, let's just randomly say, Turkey, where limitation is 3 years. But my FRAND offer contains going back 5 years. Then I think the defendant will probably have difficulties in saying that he is not obliged to accept this offer, because the limitation period in Turkey is only 3 years, and it would be against good faith that I present a license agreement which goes beyond limitation in Turkey. I think he would probably have difficult times to being heard with that argument.
So the next thing to look at, and this is the rather more controversial one, is should courts take a view in respect of the past that is different to what they're doing now. So, for example, in the UK, so far in the Unwired Planet case, which is the main one we have had where past damages are being looked at, what the court has done is they have calculated what the reasonable royalty would be going forward. And then they've just extrapolated that back, going to the past. So the end result, in theory, if they've got this right, is that the implementer has paid exactly what he should have paid had he taken a license early on, and the patent owner has received what he should have received had the implementer taken a license early on, barring the effects of limitation periods, because courts can't get around that. So there may be some saving cut off beyond the 6 years or beyond the 3 years. But otherwise, the UK has, as it were, made the patent owner whole and put the implementer in the position he should have been in. It doesn't completely solve the problem because, of course, that implementer has had a long period of time where he has benefited from this lower bill of material cost. He's been able to acquire market share at the expense of his competitors. But it does resolve the problem as between patent owner and implementer, just not as between implementer and his competitors. So that's the UK's approach. What Sir Robin and other UK judges have questioned is whether that's enough. What do they do in Germany, Clemens?
In Germany, it's actually not finally decided. There are voices who say that a FRAND or an SEP is always FRAND encumbered. So this means also for the past, you should not get more than FRAND. But there are important voices, including famous Judge Kühnen, who says that no, the patent owner cannot discriminate somebody who has never asked for a license. So he says there shall be only, let's say the license should be only limited to FRAND from the time where the potential licensee started to be a willing licensee. Before that, all free damages are available according to the enforcement directive. You know, the infringer's profit, the lost profits, or the license analogy. But here again, in practice, it sounds better than it is, because in practice that's very difficult to claim. First of all, I think in my entire career I've seen very, very few cases where lost profits were claimed, just because it means that the IP owner would have to make his case and demonstrate what kind of profits he could have made, which is in a FRAND contest especially challenging. And even if you asked for the infringer's profit, that is also challenging if you look at big portfolios, because here then you are again back to one single patent. How can you calculate damages for the infringement of one single patent if you are talking about a portfolio license for more than 1,000 patents in more than 100 jurisdictions probably. So therefore, I think in practice, the result will not be very different. But you see the differences, for example, if in Germany there is finding of infringement, which usually comes together with a decision to render accounts. Here often the infringers argue that also the rendering accounts should be limited to those information which are necessary for calculating a FRAND license rate, whereas the court still order to render full accounts, meaning also including all information necessary for calculating infringers' profits.
No, that's fair enough. And that's actually Kühnen's point is something I suppose that could be applied elsewhere. We have, from our point of view in the UK, Mr. Justice Mead decided in the Optus and Apple case that the FRAND's obligation, as it were, the FRAND encumbrance on the patents, it has two sides to it. It's an obligation on the patent owner, but also on the implementer. And it does not exist, it falls away if you have an implementer who is not prepared to comply with its side of the obligation. Now, I suppose what you could do is say, if you have an implementer who in the past has been unwilling and has only taken a license late, you could say that in the past, whilst they were unwilling, there was no FRAND encumbrance on the patents, and the price must be set in the ordinary way of patent damages. The problem, of course, we get to then is that the ordinary way of setting patent damages, as you say, one of the ways of calculating it is reasonable royalty. And is reasonable royalty any different to FRAND? I don't know. What would a willing licensor and a willing licensee in the past have negotiated? They would have ended up at FRAND. So it's, I can see the argument. I wonder whether we just end up back in the circle and back where we started there. We've also got of course, the enforcement directive that damages and compensation for IPR infringement are supposed to be effective, proportionate, and dissuasive. Now, proportionate is fine, and effective is probably fine. The question is dissuasive, and whether that sometimes gets argued to mean that there should be some higher level of damages than what a willing licensor and willing licensee would have generally agreed. We see this argument in other areas of intellectual property law coming up quite a bit.
And it brings us back to the old quest, or to the old starting point that hold out pays out. And I mean, if you just make a mathematical approach and say, I just don't take a license and sit and wait what sees, and then I think I always have some kind of likelihood that I will never get caught, because whatever, the patent owner doesn't have the possibility, doesn't have the financial resources, doesn't have the capacity, or first goes after others, and so on. I mean, there are so many unlicensed companies probably that might use the strategy just to sit and wait and wait and see what happens. And if you take that into consideration, just to make it very simple, if you say the chances of getting caught is 50%, and with that in mind, then it would, according to the enforcement directive, probably be proper to make then the damages twice as high, so that it's altogether, let's say, on a mathematical approach, should not pay out. That you say, okay, chances not to get caught 50%, but then I pay twice as much, so I will probably be ending more or less where I would end anyway. So therefore, I better act legally.
In the copyright world, of course, they've been grappling with this problem for very, very much longer. Normally in patents, that the problem is solved by injunction, but it's only in the world that the context of standard essential patents that has been so largely taken away. So it may be worth looking at what has happened in copyright. But in copyright, through legislation, we have this availability of enhanced damages, where somebody has been infringing the copyright for a period of time, either for a business purpose or in English, or we have this concept of flagrancy. In other words, not really caring whether they needed a license or not, or even knowing that they needed a license and didn't have one. And we have the additional damages as a result. Typically in your average photographer copyright case, someone who's taken a photograph and used it on their website without bothering to get a license from the photographer, those seem to be roughly the same as what the reasonable royalty would be in addition. So the infringer ends up paying double. And I wonder whether this is a concept that may one day find its way into patent law as well, or into other areas where somebody who uses patents for a period of time and makes no effort to take a license, or deliberately defers taking a license so as to give themselves a competitive advantage, maybe there will be some sort of enhanced damages available in those circumstances. If it's allowable in copyright under the enforcement directive, presumably it must also be allowable in the area of patents. But it's a pretty controversial idea, and not least because many implementers will say, it's not that I was refusing to take a license, it was that the patent owner was demanding too much. And it's quite difficult to distinguish between that scenario and the implementer who is genuinely tactically delaying his licensing. So that's one possibility. The other option is costs awards, and it is often said in English litigation that the purpose of the damages is to put the infringer and the patent owner in the position they would have been had everything gone right, as it were. And then costs awards are used to compensate the patent owner for the fact that he's had to go to court to get that situation. And do you think that's enough, Clemens? Do you think if courts were more free with costs awards, they weren't so heavily capped?
Yeah, let me say that with the cost, it's a difficult thing for two reasons. On the one hand, it's the aim of cost awards is, let's say, not to, let's say, give a specific benefit to one party, but really just compensate for actual costs. So I think that should, let's say, more not be a tool to encourage any kind of behavior. And the second problem with the costs is that these patent disputes are really expensive. And on the one hand, of course, the plaintiff who has maybe good reasons to file an action wants his cost compensated. On the other hand, it must also be somehow foreseeable for parties on either side of the table what is their risk, because otherwise I think patent enforcement at one point of time would probably get too dangerous for both sides, so that would probably also not lead to more justice. So therefore I think reasonable cost compensation is definitely important, necessary, one of the big differentiators between US and Europe, for example, but it must still be in reasonable ranges.
That's true. And of course, cost awards, again, whilst they might put the position right between patent owner and the implementer, they don't do anything to address the situation as between the implementer who has delayed paying and all of his competitors who may have started taking a license early on. They don't do anything to address that balance. So anyway, this has all raised these rather interesting questions, and maybe Sir Robin is right, and the answer is ultimately that the person who comes to the table later, who takes the license later, the the top guy on this slide, maybe he should be paying a higher rate so that his blue area is more equal to the blue area of the person who's taken the license earlier on. And ad valorem, you can see a justification for that, particularly if the price of the product has dropped in the meantime. Per unit, you could see a justification for that, because it would then put the two competitors as between themselves in a fairer position. You might have to discount the amounts that the early licensee takes, so that the SEP owner is not getting a windfall. The SEP owner is only getting overall the same amount as he should have got if both had taken the license earlier on. But maybe Sir Robin has a point. Maybe it is that the later licensee should pay a higher amount per device, and the earlier licensee should pay a lower amount per device. So those were the thoughts we had. I don't know if anyone of the attendees has questions or has any comments.
The floor is open. Any questions?
No. Well, hopefully some of the attendees will come to the conference in Munich, Roya, or attend, and perhaps pick up the discussion there, or perhaps this is a discussion that can be picked up by people at other events. What is the solution? I don't know. It seems inherently unfair to ask different people at different times to pay different rates, but also it seems inherently unfair to ask them to pay the same rate at some very later period.
Yeah, and I would be very happy to exchange also experience with other people here on this webinar, or also on the conference in Munich, because I think the challenge indeed is, just again to make it a very simple example, the license owner thinks he should get 100, and the licensee doesn't sign, so he sues. The licensee offers 20. So can it then be the settlement that you say at one point of time, okay, now you sign for 120 and I will withdraw my case? I think that will just be very, very difficult in practice to achieve. And it will also be difficult usually to explain to a court why you are now increasing your offer. And so therefore, I think it might have the same effect, just on its front, look a little bit different if you do it the other way around. If you just say probably or perform it that your average rate should be, let's say, or your standard rate should be 120, which you always ask, you always claim, and you just say, oh, but if you sign, let's say, within half a year from launching the market, or within half a year from first being approached or so, then you get 20 discounts, so that you then will effectively be paying 100. That might work better this way, but I think it will always be difficult, even if in theory all economic arguments support a higher rate for late signing. It will be difficult in practice to achieve that in court or in negotiations. So therefore, any experiences are very welcome.
Keith has put up a comment saying some patent pools have early bird discounts, and I think he's right. This is obviously trying to address some of this problem. It's a slightly digital way of doing it, isn't it, though? It's a little like the early bird conference discount, sign up discount. You either get it or you don't. It's not quite so graduated as perhaps the proposal I was thinking of here.
Yeah, some of the discounts are, of course, also aimed more to, let's say, encourage people to implement the technology, especially in a phase where possibly several technologies are in competition with each other. In the mobile telecommunication area, we don't have that so much, but we have seen it a lot, for example, in video coding, decoding standards, or so, where quite a lot of different standards are in competition, and really the early bird might to win that competition.
Go ahead.
I was going to say, Roy, why don't you do you want to give some details of the conference, and if people want to?
No, there's actually someone who sent me a message.
Oh.
Who had another question, asking to stay for the time being anonymous. Very, very mysterious. The point I think is being made. I hope I get this right. That the patents that are subject to the license are also not born on the same day and die on the same day.
That's true.
It's not like they're from 1st of January 2000, 1st of January 2020, but they also have timelines which are all over the place. The question was if there's some sort of parallel here.
No, that is true, and
that's thinking about the subject matter and the age of it, and how you From when to when do you start this? That was the question. You started from to the death of the last one and the birth of the first one. Would that been then dynamic pricing according to when most of them are still alive? Or how would you do that?
I think you're right that there has to be some sort of account taken of that, and I know that I mentioned at the beginning the arbitrations that we were talking about. One of a classic argument that takes place during these negotiations is that as people wait and delay taking a license, they say, "Oh, but SEP owner, your patents are all old and dying, and you are a dinosaur. You were very big, but your portfolio is shrinking." And the SEP owner says, "Actually, no, my portfolio is growing." And then there's an argument about, is it growing in absolute terms, or is it the share that's growing, or is the SEP owner's share being diluted out? And you do see over time that obviously SEP owners' shares grow, shrink, and change. And as a result, in the arbitration, one of the things that the arbitrations we've done, one of the things we have done is taken a license from, say, 4 years ago, when the portfolio may have been one particular size, and then scale it up or scale it down, depending on how the portfolio has changed in the intervening years. If you have a 5-year license from an SEP owner at a time when he owns 10% of the patents, then obviously it's going to be a very different rate to a 5-year license at some later point when he's been diluted out and he's only got 5% of the patents anymore. So yes, I think that is something that does have to be taken into account, and I think in practice it is taken into account in licensing negotiations, because that argument is a fairly common one.
Yeah, and I think it's a very good point. But let's add to that. It depends a little bit on the license rate approach which you take. Let's say on a top-down approach, it might not even necessarily change so much, because I think that is how we see a portfolio generally developing. I mean, usually, let's say once the standard get frozen, then we see that it takes a while till all the patent declarations, all the patent filings which have been made really lead to granted patents. So that is kind of normal. But I mean, also these granted patents, probably the patent owner is entitled to a compensation for time before the grant. So therefore, I think it will probably not make such a big difference. It does make a difference, I think, more either towards the end of a portfolio, or it might also make a difference, let's say, for small portfolios where, let's say, you basically have one patent and then you get a second one. Yeah, there it definitely makes a big difference. But mostly we are seeing plaintiffs or patent owners who have rather big portfolios, where I think the impact is probably not so big. And then the question, of course, is also, if you have a licensee who says, okay, I wait till all your applications have been granted, and then I'm willing to take a license because then I can tell much better what's the value of the portfolio. If you would consider that as the decisive driver, then you, of course, should need also to think in parallel what happens to all the early licensees. Does their rate then have to be increased so that they also, or should they get then the additional patents for free, and then the late signee pays a higher price because at the time when he signs there are more valid patents or granted patents, and the early signee, he only has a license under the patents which were granted at the time when he signed? Does he get the others for free, or does he then have to renegotiate the rate every time? So I think this brings us to a number of follow-up questions, and so therefore, at least in practice, I have rarely seen that it was really argued that now later the portfolio has developed in such a way that now the approach would be a fundamentally different one.
The other problem we're getting is that the difference, the time between starting to develop a standard in mobile telecoms and the standard appearing in products, so 5G is a really good example, that time period is now shorter than the average time for granting patents. So I'm here holding a 5G phone, and many of the patents that were applied for right at the beginning of when that standard was being developed aren't granted yet. And this is the first time this has happened. 4G, the development cycle was rather slower. 3G was very much slower. So we're in quite an odd situation now, and we certainly can't have licensing based on the waiting till all the patents are granted approach, because 6G will be along by then, and we're going to have to start doing far more on the basis of what it looks likely a patent owner is going to hold once everything has settled down.
One other question in the chat on the influence of the EU policy interest in FRAND negotiations. I think that is, if I may start with that question, Richard, I think that is at the moment very difficult to predict because it is difficult to foresee in which way the EU plans are moving. I think the EU has a lot of sympathy for more transparency. In principle, I think that is something where everybody just has to agree. I don't know anybody who says, no, we don't want transparency. It's always the question how to achieve that, how to balance between maybe confidential business information of the parties and the interest in information and transparency by the market. I don't see a direct impact into FRAND negotiations. Ideally, of course, with more information, the license negotiations will be a little quicker. And I think actually that for a truly willing licensee, that might be the case. If he has the information he needs, he might just sign the agreement. For those who, of course, think that the later I sign, the less I will ultimately pay, for those also transparency will not really move the needle because, let's say, whatever information I have, I can interpret it in different ways. I can always say why this information is to me irrelevant, why I am different than the others. And so therefore, I am not sure that this ultimately will help. Also at the moment, there's already a lot of information available through public sources, through independent studies, through databases, through a number of different means. So therefore, I am not quite sure how this EU policy review will really change the FRAND negotiations. But as I said, really remains to be seen what comes out at the end of the day.
One of the things I'm wondering on that is the EU and its policies are currently quite heavily directed towards SME implementers and the idea of a rise of a new breed of industry within Europe, which is the small implementer of technology standards. We have seen for a long time in the past this tradition of volume discounts. So the idea that the big implementer pays a lower rate than the smaller implementer. And this is one of the points that's being debated in the current Lenovo Interdigital FRAND case in the UK, which we haven't got a decision on yet. I'm wondering if one of the influences of the EU is going to be a view that volume discounts aren't necessarily such a good thing anymore. There's no reason why the big players, the Oppos, the Samsungs, the Apples, should pay a more favorable or a lower royalty rate than the person who's just coming into the market. Now, obviously, we recognize that they have the reason they pay a lower rate is because they've got bargaining power. And volume discounts are really the other side of the coin to the bargaining power of the large implementer. But whether they're FRAND or not, maybe the European Union is going to push back a little harder on that.
Yeah, I think indeed the big ones have more bargaining power. Of course, you could also argue that, let's say, the transaction costs are a little lower, whether I do an audit for let's say for 1 million units or for 10,000 units.
Yes.
But on the other hand, I mean, under competition law, we also often speak about low market entrance barriers, for example. And if, let's say, the big ones get the best rates and the small ones who just try to get a foot on the market then have as extra burden even higher rates, I think that will definitely make it more difficult, and this would raise the market entrance barriers. So therefore, I think this cannot be in the purpose of competition law to make it, let's say, for the big ones cheaper and for the new entries more expensive. So therefore, yeah, there is a lot of arguments against volume discounts, but here again, it's difficult to implement that in reality. If let's say the really big ones, the Apples put a check on the table, then for small Nokia or so, it's very difficult to say no, thank you.
Yes, at the moment, a FRAND acts as a cap. It doesn't act as a floor. There's nothing to stop the big implementer with the bargaining power arguing for less, getting a deal that is less than FRAND. And I suppose that may be, so that may be one outcome.
What is your expectation in the British policy on FRAND that is currently on the way?
So I am, yes, I've been watching with interest what's been going on in the UK IPO. One of the difficulties seems to be a difficulty of understanding. So many of the questions that came out in the UK IPO survey were demonstrated a lack of understanding of how of how it all works, and was something of a surprise to me. I don't know what is going to come out. I suspect that the outcome is not going to be very great at all. I think that there will be a review and a study and a consideration that actually maybe there aren't that many problems. I must say I'm talking here about cellular. There are other standards where there are very great problems, a very great lack of transparency. And I would, if anything comes out of the UK and the Commission process, it would be really good to see all standards having the sorts of levels of specificity of declaration and publicly available databases that there is in relation to cellular. Wi-Fi in particular is a completely black box as far as I'm concerned. I can't work out how we value that.
Then if I'm, I always love to think about the grand vision and the big things and so on. And there was one thing where you really did strike me, where I said, well, the standard development is significantly faster than the issuing of the patent grants. And on top, we have backlogs in the patent offices. But this is a mess. I mean, I have always admired how we are still able to be so operational in spite of the fact that we have a nationally fragmented patent office and patent system with many different patent offices around the world, but global businesses, and it's a mismatch. And perhaps the UPC will help a little bit bring us more. But this, what you're saying, is a whole different level of mess.
Yeah,
How could we get out of this? Are we just gonna observe? Is that like, well?
I think honestly,
what would you suggest?
I think the parties really must find a way to solve this, because, as you said, the litigation is very difficult, even with the UPC. Okay, then we have maybe 13 jurisdictions in one go, but it's of course still a very fragmented world. You still have, let's say, there's the huge industries, at least China and US and India, and then the UPC for some European countries, plus the UK, plus so many others. So it will always be impossible to litigate in each and every jurisdiction. So then this leaves us basically with two possibilities. The one is that you do it, let's say, that you do a FRAND setting. We are of the very strong view that no court in the jurisdiction has authority to set a rate unless both parties agree that that court should set the rate. And the parties can, of course, also agree to have it in an arbitration or by other alternative dispute resolution means. But I think it cannot be the solution that either party, be it the implementer, be it the patent owner, runs to a court which it considers most favorable and then asks that court to set the rate. So a FRAND setting by a decision-making body mutually agreed is one possibility, and the other possibility is, as we see it right now in the UK, in Germany, in other jurisdictions, is that you say, okay, if there's no license in place, then there's a patent infringement, and we need to litigate our patents country by country, where each patent owner must decide how many jurisdictions he needs to get to a global or to global settlement. And I hear very often the argument from the implementer side that this is de facto also a global FRAND setting, because you will ask the implementer will often raise a FRAND defense. He is so willing, but the patent owner does not make an appropriate FRAND offer. And so therefore he has then the court has to review the offer and has to decide, is this offer FRAND? What is FRAND? Does the implementer accept what that particular court considers to be FRAND? Otherwise it might be injuncted. It is a huge difference to a FRAND setting, because it's still only a defense whether there should be an injunction or not. And being injuncted in the UK or so is something completely different than being ordered to, say, either pay globally excessive royalties or the other way around, or to accept globally very small royalties, which by no means kind of cover the R&D investment which has been done. And so therefore, I think ideally the parties really try to avoid the global FRAND setting by a third body or also the patent infringement litigation, but really try to solve it on the table. And we hear so often about all these smartphone wars and so on, and I continue to state that this is not the normal thing. I think most agreements, which gets less attention, of course, but most agreements are concluded through negotiations and without any litigation. And I think, of course, with all the discussions we have, all the panels we have, all the judgments we read, there's more certainty, more information for both sides, so that this hopefully should help parties in coming to a business solution without the need for litigation, or even the need, sorry, Richard, to say that, for lawyers.
That's okay, I can retire soon. There's another question, isn't there? Is it going to be a problem that the Patent Office backlog will cause portfolios to consist of larger amounts of applications instead of granted patents? It is a problem in terms of two respects. In terms of transparency, because it's more difficult to know what is going to come out of the granting process and whether it will result in a patent or not. And it's also a problem for the person who's having to make licensing disclosures. In other words, to show to Etsy or to the SSO which patents they have that read onto the standard, because until the patent grants, they don't really know. So there is a problem in that respect, but in both cases, it's a happy problem in that we are developing, the speed of technological development has accelerated to the point where it has outpaced our administrative processes. That's a good thing. Overall, that's a good thing for society. So yes, although these things are problems, I'm far happier living in a world with these problems than one without them.
We need more money for patent offices.
Oh yes, always we need more money for patent offices, but it's a never-ending problem, isn't it?
Yeah, the problem is, I think, not only the speed of the patent offices, but also, of course, the speed of the courts, because some courts allow you just to attack a technology. I say, whatever, 4G uses my patent, but other courts are then, they're more specific and say that this has to be read on a specific product, because each product might implement the standard differently. And if you really want to litigate against a specific product, then it's really difficult to get any kind of judgment, and especially any enforceable judgment, before that product is already off the market. Just look at the iPhones. Every year, I think in September or so, they launch a new iPhone. Then you can buy it, you can analyze it, and then you can file an action, and then you will get then you will get the judgment probably at the time where the next one, or maybe even the second next one, is already launched.
Well, yeah, what shall I say? We're too creative and too innovative. The governance system needs to somehow catch up in some way, or not. Fine. I think we didn't lose that many on the way, even though we're already pretty much over time. Thank you very much. It was really interesting to get new thoughts, ideas, and perspectives. Yeah, with all of that being said, please join us for the Oxfuse IP and Competition Forum, June 2021 or 21-22, can't remember. Tuesday, Wednesday in the week of June 20 in Munich. Send an email to info@oxfirst.com, look up the email info@oxfuse.com, look up the website of Oxfuse. We hope you'll join us. We're also running it for free online, so the live stream is for free. It's no problem if you want to just listen into a few sessions. You can't make it to Munich, just join us online.
It is a problem if you can't make it to Munich, because it means you can't come for a beer with us, which we'd be very glad.
That is true. And you will obviously hear Richard and Clemens give talks.
I hope to see many in person, because very often you have the better talks, let's say, during the breaks.
Good. Yes, come to Munich, come and see us. Thanks.
Thank you. Bye-bye. Have a nice day.
Thank you. Bye-bye.